Assalamualaikum and hi. My name is Binti Muhammad Sabirin, and today I'm going to discuss on the provisions or the act that I have enacted, which is Sexual Harassment Act 2022 in the eyes of the jurisprudence. This act consists of 5 chapters. However, in this discussion, I'm going to focus on chapter 3 regarding accountability. And this chapter basically discussing on who can be the victim and what they can do once they are considering that they are the victim. Thus, we're going to see what is the correlation between this chapter and the principles under the jurisprudence. This chapter consists of 4 sections, where first section, section 6 of these provisions, provides who can be the victim of the sexual harassment, and we provide that it can be any person. The word any person here covers any person who resides in Malaysia, no matter that they are the citizens of Malaysia or not, whether they are an employer or an employee, or students and many more. As long as they were in Malaysia, despite of their gender, they will be protected by this provision. Apart from that, under this chapter also, we provide the procedure that can be followed by the victim in order to lodge the report. This can be seen through section 7 until section 9 of the Sexual Harassment Act 2022. In my opinion, this provision was in line with the principle that being emphasized in sociological jurisprudence. Why I state sociological jurisprudence? This is because the basis of the sociological jurisprudence is to study law in its social settings. In other words, it can be said that sociology is the science of human behavior. Thus, the principle of the sociological jurisprudence they examines the actual behavior of the people, including such as judges, advocates, even the criminals and citizens, while they enacting the law. The famous scholar of this school of jurisprudence is Max Weber, that by examining the way in which the actual behavior of people, we can reach the ideal norm of the legal system. This is what actually we do or consider while we enacting this provision or this law. While in the process of enacting the act, we found that the sexual harassment doesn't occur only among the women or between an employer and an employee only. In fact, it can be happen to everyone, despite of their gender, their age, their citizens, non-citizens, their races and whatsoever, or whatever job you are doing it can be happen to anybody. For instance, it can be simply happen while even you are having a chit-chatting with your friends. We believe before this, we do have a provision for sexual harassment, but it only covers for the employer and employee only. Then how about the others? How about the victim that had been sexually harassed outside the working hour? Thus, by examining the behavior of the society nowadays, we come up with this provision that covers the victim can be any person in Malaysia, despite of their background, despite of their gender, age and their races, even the citizenship. Besides, the sociological jurists also believe in the solidarity of the society. This can be seen through their famous scholars known as Emil Durkheim, where he gives primacy to society rather to individuals. He regards society as an independent entity holding power over individuals. And this is what we practice while enacting this provision under Section 8 of the Sexual Harassment Act 2022, where we can see this provision allows other person to lodge a report on part of insane person. We believe an insane person also can be sexually harassed, and thus the society can help them through their personal representative, such as their personal representative which had been appointed by the court, or even their solicitor. Other than that, we also follow the theory from the natural law, where this principle believe that law and morality cannot be separated, and it was connected to each other. Natural law theorists believe that human law are defined by morality and not by an authority figure like minister, politician, and even the government. And according to Aquinas, theory on natural law is good is to be done and evil is avoided. This is because he believed that it is the fundamental principle to maintain the morality in the law. This is one of the principles under jurisprudence that we consider while enacting the Sexual Harassment Act 2022. Referring to the chapter that I had mentioned earlier, I believe that sexual harassment was totally against the principle of natural law, and thus we need a law of provision to ensure that it will protect one's right to life in the sense of their dignity and their reputation. The main reason we include the provision under this chapter is we would like to highlight that we believe in the principle of morality, equality, as every person may be exposed with the risk to be sexually harassed. We also believe that there shall be a clear procedure to ensure that in any situation when the victim lodged report that he or she had been sexually harassed, this issue can be resolved. Besides protecting the victim, the provisions also protect the accused from falsely being accused, as we believe that false accusation towards any innocent person was an immoral act. Under Islamic law, there are two primary resources of Islamic law, which known as Al-Quran and Sunnah, or known as Al-Hadith. These two primary resources contains definitive legal rulings which require no legal reasoning from the part of the jurist, rather need to be applied as they are. This is because it is directly from the divine authority. However, even the Islamic law is derived from the divine authority, it still can be flexible within this modern time, and that is the nature of Islamic law, as it is flexible and adaptable towards all the societies and regions. Referring to the provision that had been enacted under Chapter 2 of the Sexual Act 2022, it suits with both of Islamic jurisprudence and Western jurisprudence. Under Islamic jurisprudence, it suits with the principle of masalih mursalah, where masalih mursalah literally can be understood as consideration of public interest, or it also can be referred to as securing benefit by removing the harm. According to Imam Al-Ghazali, the benefit that intended by the lawgiver for mankind in preservation and protection of their religion, life, reason, lineage, and property is in accordance with the Maqasid Sharia, thus protecting the victim of sexual harassment and providing a clear procedure to charge someone as committing sexual harassment in order to prevent from falsely accuse any innocent person or any innocent people. It can be said securing benefit by removing the harm. Thus, this provision treats everyone equally to secure their benefit, which their dignity and their life in line with the Maqasid Sharia. Allah also said in Surah An-Nisa, verse 124, this verse advocates that equality between all and says that the only good deeds may raise the status of one human over another. Thus, it can be said that what had been opined by the Islamic jurists, which had been derived from the divine authority, was in line with the Western jurisprudence. The Western jurisprudence, such as sociological jurisprudence, tends to say examines the actual behavior of the people while enacting the law, and that same goes to the principle of masalih mursalah. The authority provided based on the current situation of the society and ensuring that the society will get benefit by removing the harm. And that also what had been practiced under natural law, where they emphasize that law and morality cannot be separated. Same goes to what had been practiced under Islamic jurisprudence, where whatever law that had been enacted, it must be based on the Maqasid Sharia. Same goes to under Islamic jurisprudence, where whatever law that they had enacted, it must be based on the Maqasid Sharia. And in this case of Sexual Harassment Act 2022, it is protecting the dignity and their life. Thus, I believe that this provision under Chapter 2 of Sexual Harassment Act 2022 really suit and in accordance with the principle of Western jurisprudence and Islamic jurisprudence.